Welcome back to Legalese 123, where we are covering cases across America. Welcome back to Legalese 123. I'm your host, Missy K. I hope everybody is doing well on this Monday, January the 5th. Well, we got a couple of things going on in newsworthy as far as courts and trials and stuff. We were anticipating having the Sarah Grace Patrick case, but that has been delayed. It's delayed until August. So remember how I talk about we're headed on the tracks and then we fall off the tracks. Well, it's okay. But there's always something else going on. So I hope everybody is doing well. I hope that you had a wonderful and restful holiday break. Do you have any resolutions or any ideas that you'd like to have happen for this new and upcoming year? I have a couple. One, obviously, everybody's trying to get healthier. That's definitely one on my list. I am also very excited about my community theater that I have been involved with. I wrote a play. We just casted the play, and so therefore everybody is going to be performing my play. I'm super excited. And if you can guess anything about me, it is obviously about a court case, right? It's called divorce court. And I kid you not, it really is. And it's got all these legalese words and stuff. And a friend of mine had said, wow, that's a lot of legalese. And I said, do you know my YouTube channel? That's what it's called. So that's what's going on in my world. What's going on in your world? Let me know in the comments how it's going. And just remember to always like and subscribe and share with your friends so that you can get the latest and greatest information about what's going on in all of these cases. So what do we have today? Let's bring it up. Today we have Charlie Adelson's appeal. So if you don't know who Charlie Adelson is, we're going to give you the road so far. So I put together this little presentation for you. Charlie Adelson is married, or not married. Charlie Adelson is the middle brother of Rob Adelson and Wendy Adelson. They conspired, not the oldest brother, they conspired to unalive the Wendy Adelson. Wendy Adelson was married to Dan Markel. This happened in Florida. Dan Markel was a professor. Oh, make smaller. Here we go. Dan Markel was a law professor at Florida State University in Tallahassee, Florida. He was a very highly educated person, and he was, doing amazing things in the world of law. And wow, I miswrote this. He was shot in his garage on July 18th and succumbed to his wounds on the 19th. Well, why? Who unalived Dan Markel? So Wendy was married to Dan. They got divorced. Wendy was complaining to her mother about wanting to relocate her family from Tallahassee to the Miami area where her mother, Donna, and Harvey and Charlie resided. They separated in 2012. They were divorced in 2013. She wanted to move. Markel did not want to move the children. So Dan stated to Wendy that Wendy's mother was influencing the kids against him. Donna wanted the kids to move closer. The divorce decree stated that Wendy could not move the kids. So Dan was a huge problem, and they needed to solve the problem. Donna, who was Wendy's mother, had put constant pressure on Charlie to do something about Dan Markel. Charlie was a very wealthy dentist who knew people and could fund such an operation. Catherine Magbanawa was one of Charlie's people that he had met in the dental world. She had worked at his dental practice, and that he had allegedly asked her if there was someone he knew that could get rid of someone. So Catherine was like, yeah, sure. So Catherine hired Sigfredo Garcia and Luis Rivera for $100,000 to do a contract hit on Dan Markel. Who are those two folks? Well, Sigfredo on the left here is Catherine Magbanawaz's baby daddy. And Luis Rivera is Sigfredo's really, really good friends. The two of them had first made an attempt on June of 2014 when they rented a car from Miami to Tallahassee. They stated that they had followed Dan around, but that they had lost him. Then in July 18th of 2024, they started looking for Dan again. They rented a car, they stalked him, then they went to his house and unalived him in his garage. Was Catherine the mastermind? Well, there's lots of information that she was definitely a main player when it came to hiring the hitmen, etc. You know, there was also the bump that had happened. Charlie was eventually convicted of the unaliving on November 6th of 2023. There was a bump that happened where the FBI had the case was kind of stalled. The police didn't really have clear evidence that anybody had done it. So the bump had happened. Here is a video of it, or a picture from the video, where an FBI agent contacted Donna Adelson, who is Charlie's mother, gave him a piece of paper, demanded some money, and then that's when things started to move. Donna's mom started calling Charlie. The FBI were taping their phones. Long story short, that's when things started getting moving, and the FBI had more information on who did what, etc. So, where are we now, the players in this game? Well, Luis Rivera is the first one here. He ratted everybody else out. And so he took a plea deal. Sigfredo went to trial and Sigfredo went to trial. He got convicted. Catherine Magmanoa had two trials, and the first one was a mistrial. The second one, she got convicted. Then it was Charlie's turn. Charlie gotten convicted. Then just recently, earlier or late last year, Donna Adelson was convicted. Harvey Adelson, who is the father, has not been charged. Wendy Adelson, who is the sister, has not been charged. And obviously, Dan Markel is the one that is deceased here. So let's just go over this again. Dan was married to Wendy. They ended up divorcing. These are Wendy's parents, Donna and Harvey. Wendy's middle brother is Charlie. Donna was complaining to Charlie that Wendy couldn't come home with her kids because Dan was not allowing them to do so. So Charlie conspired with Catherine, who conspired with these two to go and unalive Dan. Dan gets unalived. The police need to figure out what the relationship was. And so these three, who were the actual killers, got convicted. They got convicted of conspiring to unalive Dan Markel. So where are we now? So we are going to look at Charlie Adelson's appeal. So he's been convicted, right? And now he gets to appeal his sentence. And he's got a really good attorney. Let's begin. I don't know how much we're going to be able to read of this. So here we go. Let me see if I can make this a little bit bigger. There we go. All right. The appellant Charles Adelson, by and through his under counsel, requests an oral argument pursuant to the rules of... Okay, that's not what I wanted. All right, hold please. Let me get what I wanted. All right. Found the right one. Here we go. Okay, a reply brief from the appellant. I'm going to scroll down. Lots and lots and lots of case law. Da 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 da. Arguments and citations of authority. The state's answer brief attempts to avoid the merits of the appellant at Adelson's constitutional claims by failing to engage with the fundamental legal principles that underlie his arguments. Much of the state's discussion focuses on minor procedural points or characterizations of the isolated facts rather than confronting the broader constitutional concerns at stake, namely the right to a fair trial and an impartial jury, and the right to a fair and complete presentation of a defense. The state lacks of substance engagement with those core issues, exposes the weakness of its arguments. Consequently, the state's brief does not demonstrate a sufficient bias for affirming the rulings that impacted the fairness and reliability of the proceedings below. For these reasons at issue, and it is addressed in turn. 1. The trial court erred by denying appellant Adelson's motion for change of venue. So remember in Charlie's case, he wanted to go ahead and have a change of venue. He felt that Tallahassee was too biased against him. So, appellant Adelson continues to rely on the argument as outlined in the initial brief, claiming 1. The appellant Adelson maintains that after and attempting to select a jury, it was clear that it would not be possible to convene a fair and impartial jury because of the extensive pretrial publicity in Tallahassee. The trial court's error in failing to change the venue violated appellant Adelson's rights under the United States Constitution, right? The state argues that the appellant Adelson waived his venue argument by accepting the jury without objection. So, in reply, Adelson's case was nothing like Manning. The Florida Supreme Court reversed on venue issue, where the defendant did not exhaust his preemptory charge challenges and accepted the jury without renewing his motion for change of venue. In fact, defense counsel Robert Murrell, prior to accepting the jury, stated, "It would appear that to us that we have a fair and impartial jury here." Nonetheless, the Florida Supreme Court held that change of venue in the case was amply supported by evidence which established that the community was so pervasively exposed to the circumstances of this incident and that the defendant could not secure a fair and impartial trial in Columbia County. So that is number 1. He's saying, yeah, schmah, I got a jury and I said everything was good and my lawyer said everything was good, but I still think that it was not an impartial jury, and therefore it shouldn't have gone through. Additionally, the state argues that the appellant Adelson's oral motion for change of venue was legally insufficient because Florida Rule of Criminal Procedure requires the motion to be submitted in writing. Notably, in both cases cited by the state in support of this assertion, the Florida Supreme Court reached the merits of the venue argument. It goes into case law, and that is what all appeals are about. You have to state a reason why you want the appeal, and then you have to support it with case law that favors your argument. And this is very, very detailed, but we're not going to go over all of it. We're just going over sort of the merits as to what they're raising. When a record demonstrates a credible risk that a defendant was tried before a jury drawn from a community that had already formed a consensus as to his guilt, as it does here, the appellate court may and should consider the merits even if a procedural rule was imperfectly followed. Unlike other claims that may be forfeited by inaction, pretrial publicity and the venue issues implicate the fundamental right to a fair trial under both the United States and Florida Constitution. When fundamental fairness is at stake, appellate courts routinely review such claims to ensure confidence in the verdict and in the judicial process itself. This court has a duty to review the record in its entirety in reviewing this claim. So the records show pervasive, community-wide prejudice born from nearly a decade of sensationalized local reporting, repeated discussions which tied the case to the identity of the community. Remember, this crime happened in Tallahassee. Dan Markell was a professor in Tallahassee, and it was very, very public because they didn't know who did it. And it wasn't until years later when the bump happened that they actually started arresting people. And so it became certainly very interesting to people in the public because and sensationalized because it was unlike somebody to be unalived in their garage, especially a professor at a university. Just it's not something you see every day, right? Um, so prospective jurors who either acknowledged bias or lied to conceal it, with some openly expressing a belief in guilty in the jury assembly room. This was not sporadic exposure, it was saturation. So they're saying basically that perhaps maybe people had lied to conceal it, to say that they weren't biased just to get on the jury, and that I'm not sure where this statement of openly expressing a belief in guilt in the jury assembly room, you're not allowed to talk about the case until the jurors get the case. So is that when they said that he was guilty? If there were some shenanigans in the jury room, we would have heard about it prior to this. So, the publicity in the appellant Adelson's case was not merely extensive; it was sustained, locally concentrated, uh, narrative driven, and personal. For nearly a decade before trial, the media repeatedly framed the case in terms of community grievance, academic loss, and the moral outrage of a unalived professor at a beloved local university. The coverage did not simply report developments, it amplified the exposure through podcasts, documentaries, social media commentary, and community forums, effectively intertwining the tragedy with a core civic identity of Leon County. Leon County residents did not simply recall the case. They had lived with it, discussed it, theorized about it, and absorbed it into a shared cultural understanding of a local tragedy. Case law, case law, case law. Enrolling. Pre-trial publicity occurred almost entirely through traditional news platforms, such as local newspapers, nightly broadcasts, and limited national reporting. In 1994, once the newspaper was folded and the television was turned off, the story ended for the day. As such, coverage was episodic and finite. There was no 24-hour social media commentary, no podcasts revisiting the case, no algorithms sending repeated reminders, no discussion threads allowing community members to reinforce one another's views, no streaming platforms released case-related content that are accessible on demand. The publicity ended at the edges of the printed page and the conclusion of the evening broadcast. Well, Mr. Efferman, that is a very, 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 very true, right? We are in the new age of technology where we are able to just turn on YouTube and here I am discussing the case. TikTok, you just scroll through it, and if you're on the For You pages, etc., case after case after case, you're bombarded with true crime, right? And this definitely was sensationalized because there were so many players involved. Who thought that a grandmother would convince his son, then to convince his ex-girlfriend, to convince her baby daddy to go unalive somebody they didn't know for money? I mean, you can't make this stuff up, people. You can't just make this stuff up. Let's continue. But the other thing too is in the day and age of technology, right? As technology advances, our laws have to advance, right? And are people getting a fair trial based upon all of social media? We've heard in many, many current high profile cases, Karen Reed, Brian Walsh, Donald Adelson, Charlie Adelson, especially this recent one with Brian Walsh. She said, you cannot go on social media at all. You are not to look at anything that might influence you. Now, I don't know if she specified specifically it was very broad as to what she said, no social media. And it was also during the Thanksgiving break, which I thought was bananas. If you are on social media, which most of us are, how is that going to play out with future trials? So, Mr. Ufferman makes a great point. It did not regenerate or amplify itself. It was not algorithmically targeted to continuously reinsert the case into public consciousness. Here, by contrast, at the time the appellant Adelson's trial, coverage of Dan Markel's unaliving had been continuous for nearly a decade, and it had proliferated across digital platforms that did not exist in 1994. According to streaming documentaries, podcasts, YouTube commentary channels, Reddit true crime communities, and numerous social media platforms. Potential jurors reported drawing information from each of these sources and others, demonstrating the extraordinary reach and persistence of the coverage. Potential jurors in 2023 could not simply avoid coverage by not reading the newspaper or watching television. Exposure was persistent, shareable, and that word reinforced, making prejudgment far more likely and far more difficult to screen out than in 1994. The state asserts that the pre-trial publicity did not originate either from the police or the state attorney's office. Appellant Adelson respectfully disagrees, but more critically, the argument misunderstands the constitutional inquiry. The question is not who lit the fuse, but how completely the fire spread. What matters is the degree of saturation, the tone of the coverage, and its effect on the veneer. And the effect here was unmistakable. Here, the coverage indisputably favored the state's narrative. Voir dire revealed a community where the presumption of guilt had already been absorbed as common knowledge. Prospective jurors who formed an opinion believed appellant Adelson was guilty. That is not a neutral starting point. That is a verdict delivered by the community before the trial even began. Whether the initial spark came from the press conference by the state attorney or local police, a podcast, documentary, an online commentary is irrelevant. What matters is the prejudice was deep, widespread, and outcome directing. The state argues that the appellant Adelson's use of preemptory challenges somehow undermines the showing of community prejudice, asserting that Adelson use of preemptory challenges also undermines his argument. Adelson did not use all 9 of his preemptory strikes until the end of jury selection, when he used his leftover preemptory challenges to backstrike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors for the main jury. In the minds of Leon County residents were truly infected, then Adelson would have run out of preemptory challenges long before the 12 jurors were seated. That's a great argument, state. All right. So we're going to kind of skippity skip because you get the gist of that one, that he didn't have an impartial jury. All right, number 2. The trial court erred by denying appellant Adelson's motion to strike the veneer panel after several potential jurors reported to the court and the parties that other potential jurors were having conversations about the case after being instructed not to do so. Okay, so this is where I said, if this was an issue, it should have come up. Apparently, I didn't remember this. As to claim 2, appellant Adelson continues to rely on the argument in the initial brief. The record reflects multiple independent reports that prospective jurors were discussing appellant Adelson's case, including expressions of guilt, after being specifically instructed not to do so. Under these circumstances, the trial court's refusal to strike the veneer panel was an abuse of discretion. Now, this is also a very, very good point. Could Charlie get a second trial based on number 2? The state's argument the appellant Adelson affirmatively accepted his jury without objection ignores the multiple contemporaneous motions and renewals of the motion to strike the veneer throughout voir dire. Defense counsel moved repeatedly to strike the panel as more reports of improper discussion and premature judgments emerged. This is not a case where a single early objection was abandoned. Rather, the defense renewed its objection multiple times, each time prompted by newly revealed misconduct within the panel. The record plainly reflects an ongoing preserved objection that a particular section of the veneer was tainted. Here, the defense counsel did not make more than one objection or motion. Therefore, the motion was renewed before the jury was sworn. Appellant Adelson also notes that circumstances in this case does not pertain to the preservation of a challenge to one specific potential juror, but to an entire section of jurors who were exposed to impermissible content or committed misconduct themselves. So they're talking about what the procedure is. All right. Additionally, the grounds for the motion stated by trial counsel were factually specific and made on the record, which ensured that the trial court and opposing counsel were aware of the factual basis for the challenge. The trial court and state both responded to the substance of the motion, leaving no doubt in its properly before the court. See Steinhorst versus State. The trial court abused its discretion when it refused to strike the panel of tainted jurors. The issue was preserved as explained above, and thus the corrected standard is abuse of discretion. But did that happen here? The state minimizes what occurred by labeling the misconduct as isolated comments. The record tells different stories. Jurors repeatedly reported that other potential jurors were openly discussing the case, sharing details, and expressing opinions of guilt despite explicit court instructions not to do so. At least 3 distinct prospective jurors confirmed these violations, each describing different speakers' conversations and opinions. One juror stated that people were discussing the case all day. Another heard someone say, "I think he did it." This was not a single rouge remark. It was a pattern of disobedience and a premature deliberation across multiple potential jurors. In response to the trial court reiterated its admonishment to the panel and removed a few identified jurors for the cause. But as defense counsel correctly observed, this did not cure the problem. We have no idea who this young man said this within earshot or how many others were affected. In short, nothing in this record supports the state's assertion that appellant Adelson received a fair trial from well-mannered, untainted jurors. When misconduct permeates the veneer in this degree, the court's admonishment should not restore the presumption of the impartiality that the Sixth Amendment requires. Given repeated reports of improper juror discussions and admissions of guilt opinions, the trial court's decision to proceed with a tainted veneer was unreasonable. The court recognized the problem, warned the panel, and removed some jurors, but declined to address the broader containment. The half measure failed to safeguard appellant Adelson's constitutional right to an impartial jury. Allowing a tainted jury panel to remain intact violated appellant Adelson's constitutional right. Well, that's a great assertion there. All right, number 3. The trial court erred by excluding defense-proffered text messages that would have shown appellant Adelson and other alleged co-conspirators communicating normally during the time leading up to Dan Markel's unaliving, to rebut the state's contention that the appellant Adelson alleged co-conspirators were making phone calls about the M during the relevant time period. Okay, as to Claim 3, appellant Adelson relies on the argument outlined in his initial brief. The state responds that none of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of the Adelson's texts contained sexual, racist, and misogynistic references that could have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. So, Appellant Adelson respectfully disagrees with each of these points. The state claims that the appellant Adelson invited the error because he did not proffer individual text messages, mischaracterized both the record and by the nature of the trial court's ruling. The record reflects that defense counsel sought to introduce the messages collectively as a single exhibit, offered not for the truth of the matters asserted, but to rebut the state's multiple inferences that phone communication between appellant Adelson and others around the time of the M related to the M itself. Because the state presented its phone call evidence as a pattern or composite rather than individually, the defense needed to enter the text messages in the same collective format to provide a meaningful rebuttal. Counsel expressly articulated the relevance of the messages, which was to demonstrate the appellant Adelson and alleged co-conspirators were communicating normally about work and day life rather than criminal activity. That the trial court suggested to the defense that it could, instead of offering the composite exhibit, enter specific text messages, and that defense counsel ultimately declined to do so, did not invite the error as suggested by the state. Invited error occurs when the party induces the trial court to err or affirmatively agrees with the challenged ruling. See White versus State. White versus State. The purpose of introducing the composite exhibit to text messages was to show the pattern of ordinary non-criminal communication between the appellant Adelson and the alleged co-conspirators during the critical time period surrounding Dan Markel's unaliving. Well, I don't really buy that argument. Obviously, one of the main points about whether things can come into evidence or not is based on character, right? Bad character evidence should not come in. If it's something that is going to put a bad light on you, it's the defense nor the prosecution should be able to put those in. So that argument is a little far-fetched. The exhibit was not offered to prove the truth of any statements, but rather to demonstrate that, contrary to the state's suggestion, the communications consisted of a routine discussions about work, family, and personal matters, and did not indicate planning, coordinating, and awareness of the M of Dan Markel. That alone established the relevance of evidence. It directly rebutted the state's inference that phone communications during the same time frame were conspiratorial and connected to the murder. Evidence that tends to disprove or I need to drink something. To disprove an essential element of the state's theory, or that it creates a reasonable doubt regarding participation in a crime. All right, so you're going to see Mateo versus State. So here's some argument. Applying the principles explained in Mateo, the trial court in this case similarly erred in excluding evidence that appellant Adelson regularly communicated with the alleged co-conspirators and that they were communicating normally about work and daily life rather than conspiring to commit the M during the time leading up to the M. Just as the excluded evidence of Mateo tended to show bias and animosity that could support the defendant's theory of defense, the evidence in appellant Adelson's normal communications was directly relevant to appellant Adelson's theory that he did not conspire with others to commit the crime, but later that he was blackmailed into paying money to Catherine Magbanowa, who in turn paid the killers. We know that that's not true. But critically, some evidence supporting the theory of defense is sufficient to warrant admission. Here, even modest evidence the appellant Adelson communicated normally during the relevant time period was enough to support the defense's claim that appellant Adelson was, 1, not involved in soliciting Magbanowa, Rivera, or Garcia to commit the M, conspiring with Magbanowa to commit the M, guilty as a principle of murder itself. By presenting the jury with the substance of the messages, the defense sought to show a lack of pattern of criminal intent and to illuminate appellant Adelson's state of mind. In urging the trial court to admit the exhibit, defense counsel articulated the relevance of the messages to appellant Adelson's state of mind. His state of mind is not that he's going to commit an M. His state of mind is normal, everyday activity. My life is the same as it was in February. I'm not talking about an M. I'm not worried about anything. I'm living my life. That's what these text messages show. The state also contends that the exclusion of the messages did not prejudice appellant Adelson. Respectfully, appellant Adelson submits otherwise. By barring the defense from presenting this evidence, the trial court deprived appellant Adelson of the opportunity to fully present his defense and to challenge the prosecution's narrative that he and Magbanawa were communicating about the M. Like the evidence in Mateo, this information was not peripheral. It was central to the jury's assessment and reasonable doubt to the appellant Adelson's constitutionally protected right to present a complete defense. Accordingly, the trial court's ruling constitutes reversible error. The state argues that the composite text message exhibit contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. Further, the state argues that the text would have likely angered the jury. But this misses the point. Appellant Adelson deliberately sought the admission of these exhibits, fully aware that some of the messages contained offensive language. See footnote 5. During the trial, the following was said. The court, the other concern I have with this is it would possibly cast even your client in a bad light. It was good seeing you, Negro. I think that he called Miss Magbanawa at some point a strong black woman. I don't know if there's any reference to the N-word or other things in here. There were with the other witnesses, but this is going to be a look at your own risk. I understand this. Mr. Rashbaum was Charlie Adelson's lawyer. I understand, Your Honor. Please review to find the most relevant nuggets that go to actual state of mind. Okay, they all go to state of mind. He understood the potential for embarrassment, yet chose to try to introduce the messages because they were of their probative value, showing normal, everyday communications and rebutting the state's inference of criminal intent. Far outweighed the risk of discomfort or prejudice to him. Oh boy. All right. So, defense counsel identified this inconsistency. Just for the record, in the state's case in chief, they were allowed to put in phone calls showing the arrows indicating that they have no idea anything said on those calls. They're essentially the same thing as putting text messages like this, except you actually see the context, right? The chain of traffic versus what is actually said. They put in every call, okay? They put in every call between these participants on those particular dates, which, by the way, correspond mostly to the days that I'm offering these text messages for. They put them in for their own purposes. I think I should be allowed under 403 analysis, what's good for the goose is good for the gander, to put in the text messages to show the pattern or lack of pattern of anything. And that's just what these text messages show. But I can just ask the questions, but I would like the record to reflect that under 403 analysis, it would allow for them. It's not being allowed for us, the court. I wouldn't exactly say it boils down to being that simple, but your objection is noted. Specifically as to what the state was permitted to demonstrate in their case in chief goes to either demonstrating motive or direct evidence of what they believe show the elements of the charges. As to those composite exhibits, and again, I don't want to get very deep into what the subject matter is, there are messages that either go to embarrassing of other witnesses or litigants in this matter, matters that are wholly irrelevant, or matters that do not demonstrate any way that the theory of defense as the court understands it. If there are portions, again, that are specifically relevant to negating either the motive or any of the elements of the charges and are not hearsay as argued by the defense, I will consider these separately. But as a composite of the whole, the 403 issues, the relevance and hearsay issues, I believe, compel me to deny their admissions. Thank you, Your Honor. So, interestingly, I see where the defense is going with this, and the defense is like, we want this whole thing in here. It talks about not just what's going on with these particular messages, but it's everything, and they don't want it to come in. But the argument that Mr. Upperman is making here sounds like he's saying it was all or nothing, was all or nothing. But the judge was like, no, it's not. You can put in portions if you want to, but you shouldn't put in all of this because it goes to embarrassment of others here. And you can't do that. You can't like disparage somebody else to make yourself look better. You can't do that. So let's scroll. Okay. So the resulting prejudice was substantial. On one hand, the state was permitted to introduce a pattern of phone calls and argue to the jury, footnote 8 right here, that they reflected communications related to. Significantly, the state emphasized this argument in its closing. The communication records tell us a few other things too. That's the June trip, July, June. This slide shows all the calls between our parties on the night before the shooters made that June trip to Tallahassee. You can see a 25-minute call from Catherine Magbanawa to the defendant at 9:17 p.m. on June 2nd, 2014. This call was placed while Catherine Magbanawa was consistent with traveling on her way back from the Comfort rental car, where the first rental car was rented to her residence. As soon as the defendant hangs up with Katie, he calls his parents' landline and he has a 25-minute conversation. On the day of the murder, we have communications between our parties, as listed here with the red line representing time of the murder. This flurry of calls between our persons of interests demonstrates the usual call pattern that we're seeing. Donna to the defendant, to Catherine Magbanawa, to Garcia, and back. So we've got all this evidence that points to the defendant. The motive points to him. When we follow the money, it leads to him. The Prius eventually leads back to him through these conspirators. And each time we have a big event in this case, we see the call flurries where all the parties are calling each other in that structure that I talked about. It goes from this one to this one to this one. It's like a chain, right? Charlie calls Catherine. Catherine calls Sigfredo. Sigfredo calls Rivera. Then it goes backwards. Then Charlie calls his mother. And then it goes up the Adelson family chain. But as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about the M or if these call flurries around these key events are just coincidence? A conspiracy can be shaped like a cluster with everybody talking to everybody. It can also be shaped like a wheel with one central hub talking to all the different spokes. Or it can be shaped like a train car, which is what we have here. As I said, one person's talked to another, to the car in front of them, etc. All right, number 4, the trial court erred when it excluded evidence that was highly probative to the theory of the defense, which was relevant to both non-hearsay and accepted from the hearsay rule. A recorded phone call from 2016 in which appellant Adelson referenced a past extortion. As to claim for, appellant Adelson continues to rely on the argument made in the initial brief and its answer brief. The state argues that the excluded evidence was hearsay, not subject to a hearsay exception, and that the exclusion did not prejudice appellant Adelson. For these reasons set forth below, appellant Adelson respectfully disagrees. The state argument regarding hearsay rests on the mistaken premise that the appellant Adelson offered his statement, the phone call, and specifically the quote, "It's not done like that," for the truth of the matter asserted. The record demonstrates otherwise. The defense did not seek admission of the record phone call to prove that extortion generally occurs in a particular manner. Rather, the statement was offered to show appellant Adelson's contemporaneous belief and state of mind, specifically that the police confronting his mother were not the same individuals who had previously extorted him following Dan Markel's murder. This brief directly supported the defense theory that appellant Adelson was a prior victim of extortion related to the M and not a participant in a conspiracy to carry it out. So what they're saying, what he's claiming is that the people who did the bump were the FBI and that they weren't the same people extorting him for money, as in the people who were extorting him for money were Catherine Magbanua, Sigfredo, and Luis Rivera. All right, that is 4. The proper evidence was a contemporaneous expression of the appellant's belief as the events of the bump unfolded. Appellant Adelson's Appellant Adelson's recorded words were made during 2016 bump incident and therefore squarely fit within section 90.803 at 3. Appellant Adelson agrees with the state that a hearsay statement which recounts observations made previously is by definition and after the fact statement of memory are expressly excluded from state of mind exception. But that is not the circumstance here. Here, appellant Adelson did not recount past events, reflecting on what he previously thought or experienced, but instead a contemporaneous expression of belief that law enforcement, not his prior extortionists, were behind the contact at the time of the bump occurred because of his past experiences with extortion. Nor was appellant Adelson, no, he knew it was the police because, well, he had speculated. He had speculated with Catherine and his parents about who was the bump, and he figured it out. It was the police, FBI. Nor was appellant Adelson attempting to use state of mind exception to explore the state of mind, intent, or motive of anyone other than himself. The state asserts that appellant Adelson attempted to offer the evidence to prove that Garcia or Magbanua had extorted him. That characterization is also incorrect. Appellant Adelson's statement was offered solely to show his own contemporaneous beliefs and perceptions, specifically that he understood the individuals contacting his mother during 2016 bump to be different people who had previously extorted him. The statement was therefore properly framed as evidence of appellant Adelson's state of mind, not as evidence of another person's actions, intent, or motives. All right, we're going to continue on. Number 5, the errors cumulatively, in this case, denied appellant Adelson his constitutional right to a fair trial. Adelson asserts that in light of the errors set forth above, he was denied his constitutional right for a fair trial. Claims 1 and 2 cumulatively affect appellant Adelson's right to a fair trial and impartial jury. Already got that. The evidentiary errors explained in claims 3 and 4 cumulatively deprived appellant Adelson of critical evidence central to his defense. All right. In conclusion, accordingly, for the reasons set forth above and contained in the initial brief, the appropriate remedy for all claims is a reversal of appellant Adelson's convictions and a remand with directions that the trial court conduct a new trial. Signed off by Mr. Michael Ufferman. So, there you have it. So, what happens when somebody is convicted of a crime? They obviously they automatically get an appeal. Who does these appeals? Well, they have appellate attorneys out there just filing appeals left, right, and center. So what they get is they get the trial transcripts, they go through it with their client, they review the materials, and they say, oh, well, I see a potential error here, I see a potential error here, we're going to go ahead and mix up some spaghetti and throw it to the wall, put some constitutional and some case law in there and see what sticks. So that is basically what has transpired in this case thus far. So what is transpiring with well, that doesn't want to come up. Okay, here we go. So at 10 a.m. on February 3rd in courtroom 1 of the third floor in Florida, Mr. Michael Offerman gets to go before the District Court of Appeal and give his statements, his oral arguments. This also can be viewed on Zoom. So join me if you would like to hear the oral arguments. It is definitely a lot different than a regular trial, right? There's no witnesses. It is just Mr. Ufferman giving his thoughts and opinions based on this. And then the state gets to give their thoughts and opinions, and they get to argue back and forth. The judges get to ask plenty of questions, and then they have a short period of time which they're allowed to make their arguments going back and forth, and then that's it. It's the end. And then the judges go back and make a decision, and they write up their decision, and then we'll see whether or not Charlie Adelson will get another trial. Just FYI, many appeals do not go back. Many appeals are denied. Because they usually look at the case law, and they usually look at what the trial court did and what the judge's rulings are, and typically they favor the judge. That's just the way that it is. There has to be something seriously egregious. So, by the way, if you want to hear about an egregious situation, you go watch Trial 4 with Rosemary Scapiccio and the information into the Sean Ellis case. That one definitely is one that needed to get a new trial. So that is all that we have going on today. I hope that you enjoyed this trial brief. If you would like to actually see and read this over yourself, I will have it posted on my Facebook page at Legalese123. Make sure you like and subscribe if you want to hear more content. And stay tuned. Will Charlie Adelson get another trial? Thanks for watching. Thanks for watching Legalese 123. If you like what you saw, please like and subscribe for more content.